The topic of today's webinar is valuation of suit and stamp duty. To speak upon this topic, we have a very special guest among us, Advocate Sahil Mangla. I, on behalf of Institute of Law, Kurukshetra University, welcome you. Over to you, sir.
Yes, thank you, Avichal. I hope the audio and video is clear.
Yes, sir, it's clear.
All right. So, firstly, I would like to thank Dr. Manjinder Guliani for this special opportunity because I don't really think I'm an expert to deliver a lecture on this, but still, I'll try my best. So, today's topic is basically valuation of suits and stamp duty. So, before going to the main topic, I would also like to give some tips and basic knowledge about civil practice and the procedure of a civil suit. So, if you wish to have a civil practice or you wish to be a civil lawyer and you wish to have a good command over your practice, I would suggest you to have like a basic knowledge of very few subjects, which I would summarize in order of priority. Like in the first category, I would put CPC, that is Code of Civil Procedure, the Specific Relief Act, and the Limitation Act. So basically, if you have the knowledge of these three subjects, you can be a very good civil lawyer. In the second group, in terms of priority, I would keep the Contract Act and the Transfer of Property Act. So basically, if you have a good command over these five subjects, you can be a very good civil lawyer. Although I can't say that this list is exhaustive, but still I would say that these are the main five subjects that if you have a good command on, you could be a very good civil lawyer. Moving further, I would like to tell you that what are the main civil suits that are usually filed in trial courts. I would summarize them as per the specific relief act mainly. At number one, I would say that suits for possession. I think you can very well understand what is a suit for possession. It is simply that some land belongs to you, and you say the defendant has like taken over the possession of that land. He has encroached that land. So in that scenario, you can file a suit for possession. Similarly, there are some other suits. Second categories of injunction. Among injunction, you can file a suit for mandatory injunction as well as permanent or prohibitory injunctions. Other than this, there are suits for specific performance where you could say that I have signed an agreement with the other party and the other party is not performing its part of the contract. So you can go to the court and request the court that please direct the other party to perform its part of the contract or the agreement. Other than this, there are money suits, like you have given money to someone as a friendly loan and he is not returning it back, or you have sold some goods to the other party and he is not making the payment. So in such cases, you can file a money suit claiming that the other party is supposed to pay me 3 lakhs, 4 lakhs, or 30 lakhs, and you have to affix the necessary court fees also, which I would cover up later. Other than this, there are declaratory suits, like someone has forged a sale deed or a will, or somehow you feel that something is not right with a given document and you feel that the court needs to set it aside. So then you can file a suit for declaration saying, praying the court that please declare so and so document as null and void. Other than this, there are suit for easementary rights, like you have a window on one side of your house and someone is blocking it. So you can file an easementary suit claiming that I have been using this window for a long period of time and the other party is trying to obstruct it. Other than this, there are two more cases. One is this rent eviction cases, like you have a tenant and no longer you wish to keep him as your tenant and you need the same property for your personal use or for your use of your children or someone else. So you can file these eviction cases under the Rent Control Act. And lastly, there are suit for torts, like you must have all read malicious prosecution, and this defamation, so slander, libel, similar cases. So basically, this is broadly the types of suits that are generally filed in the trial courts. There are other cases also like related to intellectual property rights, but I'll not touch that. Now, before coming to the main topic, that is valuation of suits and secondly stamp duty, I would also tell you what is the general procedure of a plaint or a civil suit, like step one, two, three. I'll not go into the details, I'll just tell you the basics. So, if you wish to file a civil suit, the first thing that is your suit, that is the plaint. Since all of you are in final year, I hope you understand these basic terms like plaint and WS. So, first thing is the plaint. Once you file the plaint, your court phase is right, then the court will issue the notice. Notice is the second step. Once the notice is served to the defendant, the other party, then there are two things that could happen. One is that the defendant would appear, and the second thing is the defendant will not appear. So if the defendant would appears, he'll get the chance to file a written statement. So after appearance, the next step is filing of WS, that is the written statement. If somehow the defendant, despite service, does not appear, then the court would opt for one-sided proceedings, which is known as ex parte proceedings, and Order 9 of CPC deals with that. So, if in both the scenarios, if the defendant has filed the WS or if the court has opted for ex parte proceedings, the next thing that the court would do is the framing of issues. The counsels, if feel that a specific issue needs to be framed, they may request the court, or I could say they could assist the court. Though it is said that the issue framing is a very crucial position or a step in a civil suit, and the court is supposed to seek assistance of the parties, but generally these are framed in routine manner. So if you are a counsel for a plaintiff or a defendant, and if you wish that a specific issue needs to be framed, so you may request the court in advance. Otherwise, you will have to file an application, and that would again take like 2 or 3 months. So after framing of the issues, the next step is the evidence. Firstly, the plaintiff is given the opportunity to lead his evidence, written as well as oral evidence. Once the plaintiff completes his evidence, then comes the opportunity of the defendant. Then he would lead his oral as well as documentary evidence. Once both these evidence are concluded, then the matter is moves to the final subject, final step, which is the rebuttal evidence and the arguments. Rebuttal to lead rebuttal evidence is not necessary if the plaintiff feels that the defendant has raised some new issue in his defendant in his evidence. Only then he'll have the right to lead rebuttal evidence. Rebuttal evidence is not meant to cover the lacunas that the plaintiff has left while he was given the opportunity to lead evidence. And lastly, then comes the chance for arguments. And once the arguments are done, then the final judgment and the decree. So this, I guess, was the basic of a civil suit. Like there are other technicalities also, but we can't really cover this in a very short period of time. So now the main topic, which is the valuation of suits and stamp duty. Basically, these are two totally different issues. So firstly, I'll cover the valuation of suits part. And if I have to like explain it in simple words, basically this relates to court fees. Now, why the valuation of suits is important? Valuation of suits is basically done for two purposes. Number one is the affixation of court fees, and number two for the purpose of jurisdiction. As far as the issue of court fees is concerned, you have to keep in your mind that the state amendments are very necessary to be seen by a council. See, if someone comes to you and engages you as a council to file a suit, please do not go through the central act only. The state amendments are equally important. In fact, in all the states. It is basically the state amendments that would tell you how and how much court fees you are supposed to affix on your suit. As far as the question of jurisdiction is concerned, it has lost almost its relevance because in Haryana, even a civil judge junior division has the jurisdiction to entertain any suit of any suit value. Some 1 or 2 year back, there was a distinction. Like a civil judge junior division could only entertain matters up to the value of 10 lakhs, and values suit value of more than 10 lakhs was could only be entertained by a civil judge senior division. Now, after the amendments were made in the High Court rules and orders, so basically the valuation of suit for the purpose of jurisdiction is not of much relevance. It is very important if you practice in a city like Delhi, Bombay, because there the high courts have original jurisdiction. So, conclusively, there are only two purposes for the valuation of suits. One is for the purpose of court fees, and second is for the purpose of jurisdiction. Before I move to the next part, I would like to tell you that if you come to practice, the most important section in the Court Fees Act is Section 7, which covers almost all the ways and how you have to calculate the court fees. So please, you may note it down that Section 7 is a very important section in the Court Fees Act. If somehow you come to practice or you are convinced to practice, this should be the section you will be going through before a fixation of court fees or before filing your suit. So before elaborating on this issue, I wish to tell you that I have kept this lecture very basic, because if I would go into the technicalities, it will take a lot of time, and neither you need that technical knowledge at this point of time. I have tried to keep it very basic and very small details, so that if you come to the court first day, you feel that at least you have the basic knowledge, and if your senior asks you something, you are able to answer or assist him. So uh, I'll tell you the court fees that is affixed on very basic documents. Firstly, leaving the plaint aside, I'll come to that on the last point. Firstly is your all interim applications. Like you file an application for temporary injunction, you file an application for appointment of guardian or an extrant, you file an application for appointment of local commissioner. Any application you file under the Civil Procedure Code or any relevant civil law, rupees 10 court fees has to be affixed. Along with that, on the power of attorney, court fees of rupees 2 has to be affixed. And other than this, there are two other, in fact, I would say only one other document on which you need to affix the court fees. That is for the cost of summons. By cost of summons, I mean the cost that is to be incurred to deliver notice to the other party, or we could say the defendant. So that is rupees 50. Now recently some changes have also been made, and a fees of rupees 50 also has to be fixed, but that is not court fees. That is for the advocates welfare fund. So you can't really quote it a court fees. Now comes the question that how court fees is to be calculated. As I told you that the most important section in the Court Fees Act is Section 7. Along with that, you have to consider the state amendments, which are equally important. Now, there are two types of court fees. One is the ad valorem court fees, and the second is the fixed court fees. So, as the name itself suggests, that the fixed court fees is fixed, and ad valorem court fees, by that I mean that it would depend upon the suit value. So, as far as the ad valorem court fees is concerned, it is again divided into two parts. One is which is affixed at the beginning of a civil suit. Second is which is affixed when the suit you successfully defend your suit and it is decreed in your favor. You must be wondering that what are those cases in which the court fees has to be fixed at the last. Those are generally cases related to where you, like, someone has died, and its legal representatives want a permission from the court or a direction from the court that direct all the concerned authorities, like if this deceased person has a fixed deposit account, he had some car related to his name, and like all the movable properties. So in that you file a case before the court and seeks a succession certificate so that you can use it and get the properties of the deceased person transferred in the name of the legal representatives. So in that those sort of cases, you only have to fix the court fees when you successfully wins that case, not before that. Now coming to the main issue, which is basically the main gist of today's topic, that is the affixation of ad valorem court fees at the institution of the case. So there are three things that you have to look. One is section 7, second is the state amendments, and third is the high court rules and orders. I would again repeat it that the high court rules and orders are equally important for a beginner before a fixation of court fees, because why court fees is so important and why its right calculation is so important. The main reason is that, see, if someone comes to you, the client comes to you, and you are convinced to file his case, now you calculate the court fees wrongly and you affix that court fees. If that court fees is somehow affixed, then the less it is lesser than the amount which actually was supposed to be affixed, then this could land you into trouble, because the defendant then would seek the court to dismiss your case because you have not fixed the right court fees. And if you fix a larger amount of court fees, then it leaves a very wrong impression on the client, because if he comes to know from some other source that the court fees which was supposed to be fixed was 1 lakh, and you have wrongly told the client that no, you have to affix 1.25 lakhs or 1.5 lakhs, so this leaves a very wrong impression on the client also, and it becomes very embarrassing also. Love, now this thing is all right that this is the court fees at Volram and everything. Now thing is how to get this court fees. Like we are, I have told you that you have to fix this much court fees. You like come to the, basically there are two ways to like fix the court fees. As I told you, one is fixed court fees, which is generally very less, and second is this ad valorem court fees, which might go into lakhs. So as far as the small court fees is concerned, like of rupees 2, rupees 5, rupees 50, rupees 10. So these are in form of small tickets, like we have this postal tickets. Similarly, there are tickets for court fees also, which is very easily available in the court premises, which comes in amount of rupees 2, 5 and 10, maybe up to 20 also. So like if you wish to affix a court fees of rupees 50, you can affix 5 court fees tickets of rupees 10, or you could multiply by that any court fees amount you get. Now, as far as the bigger court fees is concerned, like you have to deposit 1 lakh rupees court fees stamp papers and 2 lakh rupees court fees. So you can't really get so much tickets. Like it would go into 10,000 or 20,000. Neither it make any sense. So the way to get it, generally we don't do it ourselves. Also, there are people in the court premises who do this for us. But still, I'll tell you the process. There is a website called eGrass, which is a state website. You go to that website, you fill the details of your case, the plaintiff name, defendant, your own details. I mean the plaintiff's detail, client's detail, not your own details. Then you tell the purpose of the suit and you tell the court fees amount, like say rupees 1 lakh. So accordingly, a voucher would come out, and now you could deposit that amount in the bank. And we like it's a process of 2 to 4 days. The confirmation would come from the head office of the treasury. When all this is done, you go to the treasury office, which is mostly nearby the trial court premises. It is not an issue in the district courts. It somehow becomes issue in subdivisional courts, where the court fees papers might not be available all on all the working days. In most of the subdivisions, it is available in 2 days out of the 5 working days. So basically, I have told you that how to get the court fees. Small court fees amounts are available in the form of court tickets. And the bigger amounts, for that you need to get the judicial stamp papers from the treasury office. Every subdivision and every district headquarter has these treasury offices. One very interesting aspect is that since when COVID has come and mostly the courts have gone virtual and e-filing became a very common phenomena, we got an option to submit the court fees online also. But I'm not sure that it was a very effective way because it didn't work properly in all the states, or like it was never available in the trial judiciary or trial courts, this option. But considering all this, I would say that within 2 or 3 years we will have this luxury of filing court fees from a like from this our debit cards, credit cards, so it would become a very easier process. Moving further, I would like to tell you, I've told you the basic structure of a civil suit. Secondly, I've told you mainly what court fees is all about, what are the main acts. Before going to the next issue, I would also like to tell you that as far as court fees is concerned, there are mainly three acts. One is the Court Fees Act. Second is the Valuation of Suits Act. As far as Valuation of Suits Act is concerned, it's a hardly a act of 2 to 3 pages, and mainly there is Section 9 in that case. Sorry, the act. And thirdly, very important, equally important, is your High Court rules and orders. As far as Punjab and Haryana is concerned, the main order that you need to look upon in the High Court rules and orders is the Volume 1, Chapter 3. This would cover all things related to the valuation of suits for both the purposes, that is the court fees and the valuation of suit for the purpose of jurisdiction also. So, but I'll not go into that detail because you can all read it. There is nothing that I need to explain in that. So, the thing is that now there might be situations that where it is not possible to actually calculate what is the value of the suit and how to calculate the percentage of court fees on that suit amount. I hope you all understand what do I mean by suit amount. Suit amount is basically the value of the relief that you have sought in your plaint, and on that suit amount only you have to calculate the amount of the court fees. Now there might be a situation that where it is not possible to actually like calculate the real suit amount. Like for example, you have a piece of land and someone has encroached in that land. Like he has this adjoining land and he has like uh, constructed his wall and some part of it falls in your piece of land. So in that case, you may file a suit for mandatory injunction, and along with that, you would also seek the relief of permanent injunction. Now, you can't really value this relief because it is not an issue that relates to the monetary value of the property. So, in that scenario, you will have to go to the second schedule of the Court Fees Act, which I told you, which is the fixed court fees, which is 25 as per the state amendments. But you will also have to go through the Punjab and Haryana High Court rules and orders also. And if you are practicing outside Punjab and Haryana, you will have to see High Court rules of that concerned state. Let me tell you that the fixed court fees is otherwise rupees 25 as per the state amendments of Haryana basically, not Punjab and Haryana, because Punjab might have its own state amendments, but the High Court and rules and orders would remain mostly same for the both states. So it is 25 rupees, which is the fixed court fees, but that again would also be subject to the Punjab and Haryana High Court rules and orders. So before fixing rupees 25, please see the rules and orders also. Now, like I may say that if you file a money suit of rupees 25 lakh rupees, the question is that how you would calculate court fees on that. One suggestion that I would give you is that you need not to memorize things in a court fees. Like you do not have to cram the court fee schedule and table. You can always take the assistance. In fact, you should always take the assistance of the Bear Act. Why I said that you should always take the assistance of Bear Act? It is because to avoid any imposition of lesser or higher court fees amount, as I told you that it could send you into trouble or embarrassment, which I would never want as a lawyer. So the question comes is that how, like, all right, you filed a money suit saying that the defendant has to pay rupees 25 lakhs to me as on the file day of filing of the suit. Now the question comes that how you would calculate if that suit is to be filed in Haryana, how you would calculate the amount of court fees. For that, you would have to look to Schedule 1, Table 1, which is the table which provides for calculation of ad valorem court fees. Now, as far as Haryana is concerned, it has been very, all the confusions are gone. It's a very simple table. Like it provides that for a suit of rupees 50,000, it is 2.0.5. For a suit of rupees 2.5 lakhs, it is this amount. For a suit of rupees 15 lakhs, it is this percentage of amount. So basically, I'll not go into the details of the table. It is very easily available in Barracks as well as online. Still, if you want to show me, you can ask at the end of the lecture. I'll show you the Bare Act copy also, that particular table. Because that is the main thing that will help you when you will come into practice. And that is the main table that will guide you that how much court fees you need to affix. Now, moving further, I would also like to tell you that what is the structure of a plaint. As I told you that plaint is the first step of a civil suit. But the plaint, does it mean only the plaint? Like you write your story that I sold the goods to defendant on such and such date. He was supposed to make the payment on that date, and he didn't make the payment. So I've come to the court and I filed this suit. So is the plaint the only thing that we needs to file? Or I could say the pleadings is the only thing that would constitute a plaint. So the answer is no. A plaint does not merely means a pleading or your story. Other than that, also there are many documents. I can't say that the documents would always be same, as you could understand that it would depend on each case that what the documents are to become. But I'll tell you the main headings that are the main that are the common documents that are annexed in all the plaints or civil suits which are filed, freshly filed. So, firstly, for the convenience of the court, you would on the first page you will print out an index, as you see in all your books at Berex also. The next thing that would come, see if the court fees amount is bigger, say 1 lakh, 2 lakh, so it would be in form of the stamp, judicial stamp papers. So after the index, the first thing that would come is your court fees stamp papers. Second thing after that that would come is your pleadings or the plaint, which is generally the plaint called the plaint. After that would come all your miscellaneous applications. Like if you have, mostly you will be filing it if the issue relates to land or a trademark or something like this. You will seek an temporary injunction from the court that while the suit is pending, please direct the other party not to interfere or not to cause any nuisance to me or use my trademark which I claim to be mine. So you will file an application under Order 39 for temporary injunction. If you have filed a money suit, you will file an application under Order 38 on the apprehension that the other party is trying to sell off its property so that the decree cannot be executed. Like there are around 1,000 applications that could be filed under the CPC. It may be for appointment of guardian, it may be appointment of guardian for a lunatic person, it might be for extension of court fees. Very interesting thing that I would like to tell you that there might be occasion that you wish to file the suit the next day. But as I told you that obtaining court fees takes 3 to 4 days because you apply for it, you deposit the amount in the bank, and then it would a confirmation would come from the main treasury office, the head office. Only then the local treasury office will give you the judicial stamp papers. So You can always seek some time from the court, which is under section 149 of the CPC. You need not to necessarily mention the section. You may simply file an application seeking extension of the time. But still, section 149 is particularly meant for it. If you have a genuine reason, like sharing my own personal experience, I was supposed to file a case in the month of May when we were facing this second wave of the COVID. So the thing was that the courts were closed, but the registries were not closed. The tehsils were operating. So we had this apprehension that the other party might sell off the property and our rights might be seriously prejudiced. The suit for specific performance. The plaintiff has signed an agreement with the other party for a piece of land. He has paid some all money in advance, which is called as earnest money, and remaining money was to be paid on a given date, and on the same date the sale deed was to be executed. Now my client was present in the tehsil office, but the other party didn't come on that given date. So we have to file a suit for specific performance. So, but the trouble was that since you know that in the second wave it was so difficult to get out, and neither the registry, neither the treasury was issuing any court fee stamp papers. In that case, I filed an application for seeking extension of time for the filing of the court fees, and the court was very humble to grant me that time. Now coming back again to the series of documents that are to be filed in the civil suit, as I told you, first is index, second is your court fees stamp papers if it's a bigger court fees of a larger amount. Then come would your pleadings or the plaint. After that come would your all miscellaneous or interim applications. After that would come the affidavit. Affidavit is to be filed in support of your pleadings as well as in support of all your interim or miscellaneous applications. Even if you have filed this application for extension of time for court fees, along with that also you have to file a affidavit. Generally what we do is we file a common affidavit in support of all the pleadings as well as the interim or miscellaneous applications, and you do not need to reproduce all your plaint or the contents of the applications in that affidavit. You could simply say that the pleadings or the contents of the application forms the part of this affidavit and same are not reproduced for the sake of brevity. So basically it's a two-line affidavit. After that would come your duplicate plaint. Duplicate plaint is a mere procedural formality as per the CPC. I think it's in order 7. So it's the copy of the main plaint. It need not to be necessarily signed, or but there is no harm in signing it also. So after the affidavit comes your duplicate plaint. You may print it in both sides also. Now after the duplicate plaint would come your list of documents, and along with that all your documents. List of documents in Hindi it is commonly known as Pattar Suchi. Along with the list of documents, you will file all your documents. And as I told you that in Hindi it's known as Pattar Suchi. In the list of documents, you will mention the details of all your documents. Like if you have based if your case is that I sold some goods to the other party, then you will annex all the bills or the other relevant documents that are available to you. So on the list of documents, you will mention all the documents, and along with that, you will annex all your relevant documents. Once you have annexed all your documents, you will next step that would come is the power of attorney. Power of attorney is commonly known as Vakalatnama in Hindi, and on that you will fix a court fees of rupees 2. After that would come some procedural documents, that is your Aadhaar card. Along with the Aadhaar card, you have to affix the consent. By Aadhaar card, I mean the Aadhaar card of the client, not of the advocate. So the Aadhaar card and the consent form. And in the last would come your Talbana, which is the cost of service of summons, which I told you is rupees 50. So on the Talbana, you will affix a court fees of rupees 50. And as I told you that now there is a new requirement of ticket of advocates welfare fund also. So that you could affix on the backside of the Vakalatnama. See, the reason I'm telling you these minute details is because when I was at your stage also, I thought that all right, these are very small things and these hardly matters. But see, like if the time of filing is only till 2 p.m., which is generally 2 p.m. or 3 p.m., and you have to file an urgent case, and you reach the registry at 2 p.m. exactly at 2 p.m. or I would say at 1:58 p.m. And if there is some very small lacuna in your case, say you have not affixed the court fees tickets of 50 on the spot of Talbana or the cost of service of summons, it would be very embarrassing. Then you have to fight with the registry that please give me 15 minutes, I'll get the tickets. And he might also refuse to take your file. Then the matter goes to next day. Then you have becomes accountable to the client, as well as you yourself won't feel good that due to my lacuna or my negligence, the case could not be filed today, despite the fact that everything was ready. So you have to keep these small details into account, and please do not ignore this when filing fresh cases. At the last, you have to annex that number of copies of plaint equal to the number of defendants. If the defendants are 5, you have to affix 5 copies of plaint. If defendants are 50, you will have to give 50 copies to the registry. So please do not be negligent in complying with these small procedural technicalities, because otherwise it would become very frustrating as well as embarrassing for you. Now, one thing I would suggest, which has evolved with the like coming of the latest technology and this social media thing, the WhatsApp thing, the email facilities. See, if you are the plaintiff and you want that the service of summons is effected in the first opportunity, and like if it's an urgent case and you want everything to be done very perfectly, and like in COVID where it was literally impossible to serve summons physically. So in all these scenarios, I would suggest try to obtain the mobile numbers and email addresses of the other party. You write that email address or a phone number along with the names of the defendant in the title of your suit, and seek the permission of the court that please allow me to serve these defendants from the medium of WhatsApp as well as email also. This could help you, and let me tell you that this will be the future also. Like, for example, if you have filed a consumer complaint against some company, see, all companies have effective email addresses. So we could avoid sending physical summons, though the courts do not agree to this. Physical summons are also sent, but to ensure that the service is effected in the first time itself, if you can send the e-copy of the summons on the email or the WhatsApp also. And if the court has allowed such service, then if despite the service the other party does not appear, the court would consider it as a proper service, and that would help you to like fasten up your case. So this, I would suggest you please write WhatsApp numbers, emails in the plaint itself and ask for the permission from the court to like effect the service through the electronic modes also. Now the question comes that all right, you will write the WhatsApp numbers, you will write the email details, but whether there is any provision in Code of Civil Procedure. See, if there is no provision in CPC, you can't say that the service was legal. So I wish to tell you that it's not in CPC, though there is something related to in CPC, but a specific provision is there in the High Court Rules and Orders, which is Volume 4, Chapter 7B. I would suggest you note it down, because otherwise, when you come into practice, it would become hard for you to find this. This I also got it after very like searching it for 1 or 2 days continuously. So it's Volume 4, Chapter 7B, and Part B, Rule 1, Clause 3. It clearly says that defendants summons could be sent to the defendants in the via mode of e-summons also. And I suggest, I would consider that all of you are technology friendly people. So this would be the future also. This would become a common practice to send summons through electronic modes. So if you will make up this habit, this would help you in future. Now, the thing is that, all right, you have deposited the court fees, you have done everything, you have sought extension of time, and you have deposited the court fees after that. Now, there might be instances like the parties compromises the case, and there is a provision for refund of court fees also. So, whether it is actually possible to get the refund of court fees, the answer is yes. If the parties compromises the case and the court orders that all right, the suit is dismissed and the court fees is directed to be refunded to the concerned party, then you can seek the refund of the court fees also. As far as the practical procedure is concerned, the court, once the suit is dismissed, the court returns the court fee stamp paper to you. That will go to the office of the deputy commissioner, that is the DC. From that, the file would be marked to the office of the SDM, that is the subdivisional magistrate, on his civil side, which is SDO civil. Then they will prepare a bill equal to the amount of the court fees papers. The bill would be sent to the treasury. From there, it would be cleared. Then the file would come back to the SDM office, and there you will submit your details like the passbook, the Aadhaar card, the PAN card also. And within some time, the court fees would come back to your account. So basically, this was the basics of the court fees. There is no sense in going into huge technicalities at this point of time because neither you will be able to understand nor it is of much help to you at this point of time. Now, coming to the second part of this topic, which is the stamp duty. Now, stamp duty is entirely different from court fees, and neither it has anything to do with court fees. Stamp duty is basically related to registration of documents. Say like you have executed a sale deed, you have executed a will, or some companies have entered into a collaboration agreement. So there, as per the Stamps Act, you will fix the court fees. I will not go into very huge details of the Stamps Act, but again, I would suggest you that along with the Central Act, the state amendments are again very equally important. Along with the stamp duty, there is a registration fees also, which might vary from rupees 0 to any amount. So, like if someone comes to you and seek your advice that, see, I have to get this document registered, I am buying this land, I am selling this land, I'm executing a will in favor of my children, I'm doing this, that. So you have to, and if he comes to you and asks that how much court stamp duty I have to affix, so basically, you tell him the registration fees as well as the stamp duty. And again, you need not to memorize anything. Just seek the help of the Bear Act. These are very small Bear Acts, the Registration Act as well as the Stamp Duties Act. The exact name must be the Indian Stamp Act 1899. And the other is the Registration Act of. And again, in both the acts, the state amendments are very important. Do not go by the central act because otherwise you will be suffering from lot of embarrassment. So I would not go into further details of stamp duty because it is not that topic which needs very deep study or something like that. But there are very few tips that again I would repeat that firstly, please do not ignore the state amendments because it's mostly the state amendments that would impact your case, not the central act. And almost all the states have different court fees, different stamp duty, different registration fees. So please consider the state amendments as equally important. So I would sum up the topic here. I guess it was a good seminar for all of you and you got some basic knowledge. So before taking up the questions, three questions that were already supplied to me, uh, I would take up them one by one. One question that I have received is how much court fees is chargeable in multifarious suits? So, firstly, what is multifarious suits? Multifarious suits, in a common or a simple language, means a suit that involves more than one relief. Like I gave you an example of encroachment where you would file a suit for mandatory injunction, and along with that, you will file a suit for permanent injunction also. So you will value both your suit reliefs, you will total it, and that total amount you will affix the court fees. It's not that one relief amounts to 500 and other amounts to 1500. You would say, all right, I'll affix on 500 and separately on 1500, because that would cause a loss to the state exchequer. So you will total it as 2000, and on 2000 you will calculate it as per the schedule that I mentioned, which is of Haryana. So I guess it's clear that how you section 17 of Court Fees Act is relevant to this. So the person who has put the query may also go through that section. Otherwise, I have told you that you will make a total of your suit amount, and on that, if it's 3 reliefs, 5 reliefs, 15 reliefs, you will first value that suit relief separately. Then you will total that amount, and on that total amount, you will affix the court fees. The next question, and a very interesting question, and in fact, I would say even today, half of the trial lawyers must not be clear on this. I've received a good question. It is that whether the plaintiff is required to value the relief of declaration at the market value of the suit property. It's a very genuine and relevant question. See, I would give you an example. You files a case to the court and seeks a declaration that so and so sale deed is null and void. It was executed by fraud. It was executed through the medium of forgery, or for any reason you say that the said amount, said documents need to be declared as void. So there is a very important judgment in this case of Surjeet Singh versus Randhir Singh of the Honorable Supreme Court. It has distinguished that what is the difference, like how the court fees is to be imposed. So the answer to the main question, that whether the market value needs to be considered, is that if you are an executant of that document, say A has sold some land to B, and now A himself comes to the court saying that said document is not good in eyes of law. It was obtained through forgery. It was obtained through fraud. It was obtained through any wrong medium, and now I want the honorable court to declare it as void. Now, since A himself is a party of that document, so in that case, the amount that is mentioned in the sale deed, which might be 1 crore, 2 crore, 50 lakhs. So accordingly, you will have to calculate the court fees on that amount. But on the other side, say A has sold some land to B, and now C wants to challenge it, saying that A didn't have the right to sell it off because it was a co-partnership or a joint Hindu family property. Now C does not need to fix the court fees on the market value. He would simply fix a court fees of rupees 25 as per the Court Fees Act, fixed court fees, subject to your High Court rules and orders. So I guess this was very clear. Along with that, there is a very relevant thing, that is of possession. Even if you are not a party to the document, but you seek possession, now again you have to fix the court fees on the market value, or I would say the value that is mentioned in the sale deed. The third question, and a very interesting question that I have received, is court fees is actually a fees or a tax? I would say this is a question that is asked something out of the Bare Act because I see the other two questions from the Bare Act. See, before answering this question, I would like to tell you that an oral remark came from Justice Chandrachud in a recent Supreme Court case. Now, what the legislature has done, it has literally wiped out a distinction between a tax and a fee. They are claiming fees under the name of tax, and they are imposing taxes under the name of fees. But as far as the present question is concerned, a court fees, I would say, is a fees and it's not a tax, because you don't pay taxes to the court, you pay taxes to the government. So it's a fees, not a tax. Now, if there is any other questions from the live audience, they may please ask.
Anyone? The students from 4th year, 7th semester, if they want to. Yes, Avichal, take up the question. Saksham has raised the hand.
Saksham, you may speak.
Good morning, ma'am. Good morning, sir.
Yeah, hi, Saksham.
Sir, as you mentioned in the starting of this webinar, that CPC is very important for understanding of this law.
Yes.
Basically, valuation of suit. So, sir, how can we make a good command on CPC? Because, sir, as you know, it's a very bulky subject, sir.
It's a bulky subject, but I would say it's an advantage to us. You have very rightly mentioned that as far as I remember, CPC was in 2 semesters also, and all the other subjects are in 1 semester. It's right that it's bulky, but let me tell you that there are very less number of judgments that you have to read while going through CPC in compared to any other law. Dr. Poonam is also with us, and she might tell you that when you read IPC, the number of judgments, like with each section, there are 3 to 4 judgments. Now, as far as your question is concerned, that how to have a good command over CPC is half of the CPC, I would say, is learned in college, and half of the remaining half is learned in the courts. And second thing is that never rush through CPC, or see, when a case comes to you, when a client comes to you, do not hurry up, do not get like frightened or afraid that if you take some time you will lose that client. When a client comes to you, borrow some time, say that, sir, I need a week to prepare this case. Now after that, you firstly sit, think, do not do the books directly. You think that the client has come to me, this is the case. If you apply your common sense, what is the thing that you need to study? See, if the client is of 17 years, you cannot directly file the case. You can only find the case through a next friend, or you could say a guardian, though the guardian is the wrong term that is used for a plaintiff. So read CPC very carefully. And next thing is that do a research. If you are practicing in Punjab and Haryana, the best thing is you purchase a software called Law Finder. It is the software that is used by the judges also. So, and let me tell you that you can't learn CPC in a year. Like you cannot be an expert in CPC within a year. Firstly, tell yourself that this subject takes time. This subject is continuously evolving, and when you will practice, you will learn it with each passing day. You can't simply learn it by reading the CPC. When you will actually see the effect of CPC in real court, you will automatically will have a grip on this law. Then other than you have got great teachers, coachings, that I need not to tell that which is the main source of learning. I guess that you have got your answer.
Yes, sir. Thank you, sir. Thank you, sir.
Okay, most welcome.
The floor is open if anybody else wants to ask any question.
When I was a student, I used to ask a lot of questions.
That is why we brought you here.
So nice of you, man.
I guess we have satisfied the queries of Vichal. Proceed further.
Sure, ma'am.
We have a new question. We have a new question.
Sudeep, you may ask your question, please.
Good morning, ma'am. Good morning, sir.
Yeah, hi Sudeep.
Hi, sir. Sir, my question is, sir, how stamp duty is collected on collector rate or market rate, sir?
No, you can't say it's on collector rate or market rate. You firstly have to go through the Stamps Act. From there only you would, it's a different phenomena for all documents. Like for a will has no market value, right? So in that you neither has to impose the stamp duty on the collectorate nor on the market value. It has to be as per the Stamps Act. And again, I would repeat that consider the state amendments also. It would vary with each document. On all the documents, stamp duty is calculated differently. It would depend on the sale deed. See, for example, it's a sale deed, then the stamp duty is on the market value. If it's a will, it's neither on the collectorate nor on the market value. It's a very small amount. I exactly do not remember what's the amount. Like in Haryana, if you transfer something to your sister or your sister transfer something to you, there is no stamp duty, it's zero. It is generally commonly known as transfer within blood relation. It's almost like a gift. So in transfer within blood relation, there is zero stamp duty. There might be some registration fees. So the answer to your question is that there is no fixed phenomena. You will always have to go through the Stamps Act, the state amendments. Only then you can say that this stamp duty would be on the market value. It might be on the collect for a collaboration agreement. It might be on the on the collector rate. And for some documents, there is no stamp duty, there is zero stamp duty. For some documents, there might be rupees 10, might be rupees 20 or 100. So it would vary with each document. I hope this satisfies your question.
Yes, sir. Thank you.
Mostly.
Yes, Sukriti, you may ask your question.
Okay, good morning, ma'am. Good morning, sir.
Yeah, hi.
As you have said that there is no stamp duty in case of transfer in blood relations. So,
Yes, right.
if there will be any stamp duty on the same if some consideration is paid in lieu of that transfer.
If yes, it's a genuine question, but if there is a passing of consideration, then it won't be a transfer within blood relation, it would become a sale deed. I hope you understand this.
Yes, sir. Okay, sir. Thank you.
Transfer of within blood relation is almost like a gift, though gift is a separate thing. But ever since the stamp duty has been brought down to zero, it's almost equal to a gift. Now, as far as your question is concerned, that like A is the brother and he transfers some property to B, which is his sister, and there is passing of consideration of rupees, say 5 lakhs, 10 lakhs. So that no longer would be a document which could be termed as transfer within blood relation. It would officially be a sale deed. It's like just like a stranger. If A, B were strangers and A sells some property to B, A sells something to B, it would become a same transaction. It would be a sale deed and stamp duty would be applicable in it as per the Stamps Act and state amendments. I hope this satisfies you.
Yes, sir. Thank you, sir.
Okay.